Yes, Mr. Kimber.
And so to the directive in tab 1, Mr. Fraser will in due course be saying something about the regulations in the same context, so I'm going to be careful not to replicate. Plainly, Article 4 is of some importance, page 16. And in that regard, we place considerable emphasis on the opening words, in making operational. So Article 4, as we canvassed this morning, plainly requires the setting of environmental objectives, but the context for what follows in the important 4.1 is to look at what is provided in the context of in making operational. And it was for that reason, during the course of this morning, I placed particular emphasis on implementation of measures. And in that regard, we see that the key Article 4.1a.2 is concerned with the aim of achieving. What we're concerned with here is the aim of achieving good surface water status. And that language is to be contrasted with what we find elsewhere in some of these parts of 4.1a, which are more directive as to shall implement. Shall implement is a phrase we see throughout Article 4, but here in 4.1a.2 we're concerned with the aim of achieving, and that's also of some relevance having regard to the way in which all of this starts off in making operational. As I emphasised before the lunch adjournment, I don't make these points in any way to seek to dilute the ambition or the challenge which is being taken up to achieve the environmental objectives, but simply to place them in their proper legislative context. So far as achieving good surface water status is concerned, that, as the court has observed, is something which is to be done at the latest 15 years after the date of entry into force of the directive. That's what was anticipated. And as we've also observed this morning, there are in fact what we might call derogations in that regard. As we've seen from the descriptions in the CIS document, it's an iterative process via the plans and the programme of measures to seek to achieve the environmental objectives. The key focus of the case is the relationship between Article 4 and 11. I haven't finished with Article 4, but I will come back to it. But it's important to place Article 4 in context of Article 11 as to the programme of measures. The programme of measures at Article 11 expressly and immediately refers back to Article 4, and so that is what the programme of measures is plainly aiming to achieve. There's common ground about that, but it's worthwhile understanding straight away in some detail what the measures are from the annexes, and the annexes which are particularly relevant are at pages 86 and 87, Annex 6 and Annex 7. As far as Annex 6 is concerned, it's split into parts A and B, being respectively the basic and the supplementary measures. Annex 6 is helpful in that one sees immediately the directives which pre-existed this directive as being
Page 86.
Page 86, I do apologise. One sees immediately the directives to which I alluded when we were looking at the European Commission communication, which started off the preparation of the framework. So framework, building that framework around the existing substantial range of environmental directives extending from birds to wastewater treatment. Whereas Part B is plainly discretionary, may choose, and not a closed list. We see from the final Part B measure other relevant measures, so not a closed list. But what we have so far as measures are concerned, and per my Lord Justice Fraser's question earlier, I gave the off-the-cuff example of training, etc., and we see at 15, 3 from the bottom, educational projects. And so measures are all-encompassing and of a wide variety of types, of course, all focused on trying to address the pressures which have been identified pursuant to the characterisation of the basin. So one has there in one page an indication of the sorts of measures which must be in place by reason of various directives and which will necessarily be national in scope, and also supplementary measures which are discretionary. While we are on pages 86 and 87, the court can see Annex 7, which relates to plans. The last part I'm going to come to in a moment. Actually, no, it's not. What I'm going to do is just draw attention to the way in which Annex 7 is set up, because the court will recall we went through particular steps in the CIS document, and you can see them here. You can see 9 steps throughout Annex 7. You can see in Annex 7A1, characteristics. First thing you do, describe the characteristics. 2, second thing you do is you find the pressures. 3, take into account protected areas, those areas which are subject to the Habitats Directive, for example. 4thly, monitor. 5thly, list the environmental objectives under Article 4, and just pausing to look at the detail of that, for surface waters, groundwaters and protected areas, including in particular identification of instances where use has been made of sub articles 4, 5, 6 and 7. Then the 7th point, looking at, 6 is the economic.
Would that last requirement require identification of the approach to be taken to particular water bodies?
It's my lord at the 5th point.
Yeah.
Yeah.
With the reference to Article 4, 4, 5, 6 and 7.
Absolutely. Absolutely. Yes.
To in those articles.
My lord, yes. Yes. Very much so.
Thank you.
And then 7thly, we get to the programme of measures. And for the purposes of the plan, as my Lord Justice Holgate has identified, it is a summary of the programme of measures which goes into the plan.
But picking that up on that point, if you look at paragraph 6, 7, 7.1, also going back to 2 and 1, a lot of these headings are prescribed in terms of a general description or a summary.
Yes, I quite agree, yes.
Presupposing that there is some earlier stage when these things have been done in more detail.
My Lord.
What detail is another question?
Yes, and that is a point which requires a full answer, and that is an answer which I will give for certain.
I mean, for there to be a summary of the programme or programmes of measures, there must first be
absolutely
such.
Yes,
programs.
absolutely.
Can't be the other way around.
That would
I
be,
don't think it can.
no,
Can it?
no, it can't. Turning the page to 88, the 8th and 9th points are really, 8 is a register of more detailed programs, and we see that the last 2 points there, 10 and 11, are essentially consultation. Competent authorities and those who are going to be consulted.
Yeah.
So,
What's the reference to any more detailed programs? Is that the European equivalent of what we know as Regulation 32 in UK regulations?
yes, it is. So the two annexes, one relating to the other, of course, as the senior president has indicated, you create the programme of measures and summarise it for the purposes of the management plan.
Just picking up that last question, in terms of the directive, it might be Article 11.4, page 27, the second paragraph.
I can see why my lord suggests that.
Tie it together, that's all.
I would invite the court, in respect of that question, to turn to Article 13 on page 28.
Sorry, you're right, because that's 11.4 is dealing with the programme of measures, isn't it?
So, precisely. And so
Yeah.
Article 13.5
Yeah, thank you.
ends up at Regulation 32.
Thank you very much.
So, returning to Article 11, page 25, in a similar way to the annex, we have the various measures split out, basic in 11.3, and then progressing to deal with supplementary at 11.4, as our Lord Justice Holgate has just identified. The key question here, which I said I would give a full answer to, is to what extent does any of this material in Article 11 require that there are measures within the programme, measures which are specific to an individual water body. So far as the basic measures are concerned, they, along with its Annex 6, are very much concerned with measures to be applied, measures which are to be created and made available at a national level.
Where do you get that from, please?
Firstly, from the Annex.
Or Part A?
Yes.
Yeah, I mean, can I just flag up that you have to be a bit careful about how much of the directive we look at, because the regulations tell us to ignore certain parts. From memory, we're told to ignore Part A of Annex 7. Why, I don't know.
Thank you.
Well, I may be wrong,
no,
but
no.
that's from memory, that's...
Yes. So far as...
I mean, you get that from Regulation 2, I think.
Yes, as to the definitions.
There's the definitions, there are some WFT definitions which are altered by the regulations, and otherwise WFT definitions apply, but we're told to ignore certain provisions, I think it's set out in Schedule 2.
Yes. And So the overarching submission is that the regulations are effectively incorporating the directive. But I do agree that there are some modifications and there are some necessary indications, as I sought to explain via the point source example, of the way in which the 2017 regulations fit in with the national measures and indeed impose duties in that regard. So the question which I'm answering is, well, where do I get basic measures being primarily focused upon national measures? But taking it from the top at 3A, that's plainly dealing with community legislation which has to be implemented, or did at the time. 3B, dealing with Article 9 matters. Article 9 matters are economic, which I don't propose to address in any detail, but the framework itself requires that both nationally and for river basins that there is in place measures to ensure that the costs of water use are in fact recovered. And that's plainly something which has to be at a national level. 3C is much the same point as to efficient and sustainable use. 3D is looking at drinking water requirements. So again, as the senior president identified right at the outset, this is a framework which is holistic and looking at the topic of drinking water quality. That is again something which is necessarily addressed at a national level. 3E is rather similar to what I submitted in respect of discharges, in that there must be a system of authorisation or licensing in respect of the abstraction of water, because that evidently has an impact on both quantity and quality. So E is for a system of licensing, permitting or similar to address abstraction, which will necessarily be national in scope, which leaves me with F, which is rather specialist because it deals with artificial recharge of aquifers. As it happens, there is one such scheme in London, but that's probably a digression. So that is where we get to, we get dealt with G already. If we turn the page, we're then left with a range of other matters. Diffuse sources at H, liable to cause pollution, measures to prevent or control the input of pollution. Controls may take the form of a requirement for prior regulation, such as prohibition. And those are evidently national in nature, as they're concerned with controls. Okay. My learned friend, Mr. Fraser, and the witnesses that he relies upon give some examples of them. So I can go through the rest of them if necessary, but much the same point arises in respect of each of them. But so far as we have, in fact, an open list, as I've already submitted, it's now probably the best time to go to see how they actually play out at in the programme and plan that we're concerned with. And if in that regard we could take up the supplementary bundle, firstly at tab 2, and then to look at the spreadsheet in A3, which I handed up this morning. But so far as tab 3 is concerned, this is specific to the water body that the first respondent is particularly concerned about. And at 157, the classifications are set out for 2019 by reference to the key parameters, elements per the directive, which require to be classified under the general headings of ecological and chemical.
Could you just give me the page reference, please?
I do apologise, my lords, it's 157.
Thank you.
And one can see playing out in that list some of the references I made to earlier. So in respect of chemical, at the second hole punch, within a subheading priority hazardous substances, you can see playing out there that part of the overall framework which controls hazardous substances directive, finding its way within the scope of the Framework Directive. And above that, in respect of the ecological classification, that's split out in respect of biological and physico-chemical elements. And here we have, in actual fact, the example which I was giving earlier, if we go down below physico-chemical quality elements, third one down is phosphate. And that is something which is being characterised and monitored for the catchment and for the particular water body concerned. And as a result of the monitoring undertaken, the status in respect of each of those elements is recorded from fail through to good. We then get reasons for not achieving good, and that's the table on 158. And the reasons for not achieving good are split out by reference to the sources which are identified, the two sources which are identified in the directive, both diffuse sources and point sources, along with other effects such as physical modifications and the activity, the category of impact, the category of pressure, then indicating the element of the classification which is affected. A problem in preparing this case is that now this programme of measures and indeed the plan is web-based, and turning something which is web-based into paper is not entirely straightforward. But if you want more information, on the web version you can click and get there. Then further analysed on page 159 by reference to particular management issues, and we see here that in the first column it's physical modifications, which has the highest number of reasons for not achieving good status. So agriculture, urban transport, recreation are the way in which these reasons for not achieving good have been classified. One has then, per Article 4, what the objectives are, at 159 over to 160. I don't propose to say very much about the protected areas within the catchment, but they're set out on 161. But I do ask the court to go to 163, which identifies particular water bodies under the...
Well, you passed over protected areas, I follow that. But just below that we have monitoring sites which are being used to classify this water body. So part of the material you're taking us through has covered monitoring of individual water bodies.
Yes.
And in part that monitoring has been used to arrive at the classification.
Yes. I apologise, I should have alighted upon that.
I just want to make sure I'm keeping up, that's all.
So under monitoring sites, the first site is Costerbeck, and it shows the dates of the monitoring in the second column.
I think a large number of them are all Costerbeck, aren't they? They're just in different places of Costerbeck.
Yes. Now, so far as how this translates into classification by reference to, for example, fish, we see that at 163. And what one has following works like this. So if one at 163 takes the ID 563088, that material, if it was a web version, would take you to the page which we have at 165. So at 165, you see reason for not achieving good, 563088. If one was doing the web version, that would take you to that page, and that would be material which is available in the Catchment Data Explorer, basically the repository for the information about the water body. That is the information which is held and indeed is publicly available, and one can do the same exercise for other of those monitoring locations set out on 163. But it's unnecessary to go through those in any detail. The upshot of what one has is an understanding of the ways in which a particular water body is performing by reference to the criteria which are in the directive. The Catchment Management Explorer is not the programme of measures. Rather, the approach is to characterise the water bodies, understand what the pressures are within the basin, and then produce a programme of measures to address those pressures.
So I thought you just said the CDE did not include the programme of measures.
My lord, I do apologise.
So I thought you just said that the CME, does not include the programme of measures.
The Catchment Data Explorer.
The Catchment Data Explorer, sorry.
Yeah, well, absolutely. The CDE is not a part of the programme of measures.
Nor does it contain measures.
Correct.
What it does is to deal with the prior steps of characterising and describing what is there and the pressures.
Yes.
And this is the outward facing part of the database.
It is.
It's what the public can see.
It is. Exactly. I hope I haven't gone over that too quickly. My learned friend Mr. Fraser, I know, will be able to assist further in that regard. Well, so far as the next...
Sorry, just to get the submission then that flows from all this.
Yes.
What is the submission?
The submission that flows from this is that there is in place the means publicly available to understand the character and pressures in respect of individual water bodies so that one understands the measures which are necessary for the river basin district.
But without this information, you couldn't understand the measure.
Exactly.
But it may not tell you what the measure should be.
My lord, I don't accept that.
Why,
If
you
it-
use the word may.
The reason I don't accept that is that one has a full characterisation of the River Basin district, which permits and enables the identification of the measures which are appropriate to that River Basin district.
Yeah, I understand.
So
I understood
the
that
data
first-
is
the
very
first
good.
time. I understood that the first time you said it. Without this data, you wouldn't be able to identify measures.
Of course. And indeed, you'd be
But if I look at the pages you've just been taking us to, like 173, it tells us something about the characteristics and the performance and the pressures, but it doesn't identify the measures.
no. Nor should it,
No.
because that's the base data from which one then
Goes on to the next stage.
exactly.
Yeah.
Exactly.
Just to help me keep up, the next stage would be called what?
It's creating the programme of measures.
Right, so let's pursue what my Lord Justice Holgate just asked you about 173, which is the location 563099. You can't tell what the measure is there because, as you say, this document's not designed to
Yes.
produce the measure or lead to the measure. The measure's not expected to be included. If I was an interested member of the public, I wanted to see what measure was being adopted for 563099. I wouldn't find it in the programme of measures because that's a much higher level document, isn't it?
Exactly. That is exactly the point.
So where, well, yes, well, whether that helps or not, but so where would the specific measure to correct 563099 be found?
My lord,
Is that one of the inward facing documents?
my answer to your question is a matter of approach. If my lord approaches this issue on the basis that the programme of measures will find the detailed answer to how specifically the Costa-Beck would meet the environmental objective, you won't find it.
No, I do understand that. I'm not trying to be difficult, but the reason for my question was your submission, which I wrote down quite carefully, where you said there is in place the means for someone to understand the measures necessary.
Yes.
If it's, well, just tell me where is that? What would you call that?
So that is the programme of measures, which is the assessment of those measures which address the pressures in that basin district. That is why it is a strategic plan and it's a strategic set of measures. Seeking to provide an integrated approach to managing water quality across the basin. But if, as a matter of approach, if you start from the position that you're expecting the plan and the programme of measures to provide the detail at a water body specific level, that's missing the point of the strategic level, district level identification of measures, which all comes back to why the directive is set up to ensure that you have that administrative unit, but you are tailoring measures to be consistent with the particular conditions in that part of that member state. And that then comes through to the reporting requirements, the way in which this is reported.
Is that the plan? When you say the reporting requirements, what are you referring to?
But the plan is a reporting
Yes.
requirements, yes.
Every 6 years?
Yes.
Yeah.
Yeah. And of course, very important to that will be the programme of measures which is summarised. There's a clear nexus between the two.
Well, in this case, it's one and the same.
It is, yes. As a matter of absolutely, my lord. As a matter of practice, the Environment Agency have put the two together.
So do you describe the programme of measures as a strategic level plan or programme?
Yes.
Yeah.
It is. It's strategic. It's across the whole basin, and in due course, I haven't yet been.
Well, it's strategic in the sense that it does not need to descend to the level of the water bodies.
That is my submission.
It may do so,
It may.
but if it doesn't do so at all, save where the legislation otherwise expressly requires, that's okay.
Yes.
If it is prepared on the understanding that it cannot include water body specific measures, that be an error of law?
It would,
Because?
because it can.
So that would be a misdirection of law.
Yes. It would be a misunderstanding of. May does not have to.
Just on the same point as my lord's just raised, would you be kind enough to look at the skeleton from the Environment Agency? And they cover this point in two places. One is paragraph 6. Where they say that this point is agreed with the Secretary of State. On page 60 of the the EA considers the legislation correctly and does not require the programme measures itself to be water body specific.
Yes.
Instead, the programme operates at a level of generality and only becomes water body specific at the point of implementation of the programme.
Yes.
Is this approach one which you endorse?
Yes. And so the example, that's why I went to the point source. That's why I chose that. Because that's going to, the implementation, because it's point source, is bound to be focused upon a particular water body. The point of implementation. The point of implementation of the national measures in terms of permitting can only be water body specific when the decision is made.
That seems to imply it can't be water body specific before the implementation stage.
I don't, that's not the way in which I would put the points. The way in which I put the point is altogether more simple than that, which is that the measure is plainly generic, or it may be relevant only to the district, but when it comes to the point of implementation, I endorse and adopt what is said in paragraph 6, and it's said elsewhere within the skeleton argument. Later on in the skeleton argument, the same point is made as to implementation, and it's a matter of practical reality that has to be water body specific, and that's all going to be. It's all going to be it's all going to gradually accrete and accumulate in terms of improving water quality in the basin as one makes individual improvements at specific points in the basin. We are, of course, focusing on point sources because I started that, but we are likewise, by the framework, invited to consider diffuse inputs, and that may be a completely different situation. The diffuse inputs may affect the entirety of a basin or a large part of it and require the implementation of measures which will affect many more than one water body, particularly if that's connected with the spreading of manure or the use of fertilizers, for example, or the way in which land is managed in a variety of respects, often agricultural in context, which wouldn't be water body specific, but I do associate myself with paragraph 6 and what is said later on in the agency skeleton. If I could invite the court to go to the programme of measures, which is at tab 3.
Forgive me, just before we leave tab 2, one other question from there. You took us at page 159 to the objectives. So those are the, so far as the deck is concerned, those are the Regulation 13 objectives, are they? From the bottom of page 159 through to the top of 161.
Yes. Yes.
It may not matter, but the last column of that table is headed reasons. And I'm looking to see what the objective is. I mean, take the first one, ecological. The status is good. That seems to be the objective one should aim for under Article 4.
Yes.
And then the reason says disproportionately expensive, disproportionate burden. So good status prevented by, etc., etc. Significant impact on land use if you're going to get to the good status.
Yes.
So that those seem to be reasons for discounting the good status. So I'm left wondering what the objective is.
Mr. Fraser.
Thank you. Sorry, I interrupted you. You were about to take
No,
us
not
to
at all.
the measures.
On the measures, there's just a few points to pick up by way of illustration of that which we have been canvassing already. And I can reassure the court that we are making good progress and we will be on time. But I want to pick out, if I may, two of the blue measures. So on the left-hand column,
This is page.
it's actually page 176.
Oh, this I find still impossible to read. I don't normally wear glasses, but even with glasses, I still can't read it.
I respectfully agree that it's still difficult.
No, impossible.
Is it possible to get this enlarged still more so that we can read it easily?
That will be done.
I think it will help us.
So I will read two parts for the purposes of my submission, which can be shortly made. And so I will provide a further blown up copy, which will refer to the 7th row down, which is the water industry asset management plan price review and the water industry national environment programme. So that's the WINEP that I've referred to. So that's a national, it's a measure which is required by national, required by statute. And that is the example which gives rise to the measure of sewage treatment improvement by changes to licence conditions at specific sites. And so that is really closing off that which I've been submitting in respect of point sources. So I've been dealing with 11.3G and the environmental permitting regulations, and that being a national measure. And in respect of this plan, we find it as a measure within the programme of measures with a view to the amendment of discharge consents. That is a measure which is broad and generic, but would be applied in accordance with other regulations on the basis of the particular circumstances of the discharge concerned. In contrast, we also have within these measures the approach of under the same measure or mechanism, namely the Water Industry Asset Management Plan. The very first column, Water Industry Management Plan Price Review, giving rise to, in the third column here, habitat restoration or cessation or creation and species recovery.
Which row is this?
So this is the first blue row,
Yeah.
and it is the third column, measure information, and it's concerned with restoration, removing barriers to fish movement, tackling invasive non-native species, and achieve the objectives of water-dependent sites of special scientific interest and European sites to conserve and enhance them, so protected area point. And we see that from the very last column, is not concerned with matters nationally, but it's concerned with particular areas, and they're there listed. So some are national.
I can make out East Midlands for some rows and Cumbria and Lancashire for others.
That's right.
So this document is a national analysis, but
So
distributed between different regions.
yes, and we see that some are
And
concerned.
forgive me, we're not regional. The word I can make out, national, appears in the last column.
Yes, that's right.
Do we need to know anything about the blue in the penultimate column, or can we ignore that?
For my purposes, we can ignore that.
So some of it descends to a particular county. Such as Yorkshire. See page 179.
My lord, yes.
And then if you go back 2 columns to the left of that, you've got a heading lead organisation, yeah?
Yes.
And then you've got, for example, Groundwork North East and Yorkshire Wildlife Trust, Hull and East Riding Catchment Partnership, Yorkshire Wildlife Trust, and so forth. Is that relevant to have that in mind as well?
My lord, indeed it is. So I've made the submission that the measures are identified, but they are implemented via quite a wide range of other participants, actors, and decision-making bodies. Some with statutory basis that I've referred to this morning. Others are charitable.
Well, are you saying that when one puts those 2 pieces of information together, that's to say in the Yorkshire set of entries, and then the lead body refinement for that lead organisation, that one gets down as far as water body specific measures?
No, I'm not submitting that. I'm submitting that it is a series of measures which is appropriately focused for the basin, because it's dealing with the characterization and the identification of pressures. The pressure is identified and a measure addresses the pressure, albeit that it may be in respect of a particular part of the basin.
Right. So, so sorry if I'm being clumsy with this. Forgive me for that. Does this document condescend then to water body specific measures?
No, it does not.
And that's, you say, perfectly legitimate.
I do.
Because
both the requirement and the efficacy of the process is dependent upon having measures in place which are strategic in nature and are addressing the district.
and that corresponds to which provision of the directive?
And so that is the correct interpretation of Article 11, none of which requires that there is a measure for a specific water body. And that's the essence of the case. Now, Mr. Fraser is going to pick up on the way in which some of these matters play out in terms of the regulations, and I'm going to leave to him the point which arises out of Article 13.5 and Regulation 32 as to other measures. I'm going to leave that to him, and I will in due course adopt that, but I want to make progress and give him a proper opportunity. Ms Pindham isn't going to follow on, but I want to make sure that Mr Fraser has a full opportunity. Having trampled over large parts of his case, I don't want to trample over all of it. What I want to do now is to say something about those points in the context.
The document in the supplemental bundle.
Yes.
You've been very helpful in showing how this has been put together. Would you mind please going back in the supplemental bundle to page 4?
Of course.
Which gives a sort of content sheet for the River Basin Management Plan. Without descending into the detail, the first blue topic is introduction. Is that page 5? It's not very easy to follow this, I have to say.
I agree.
Implementing the plan starts somewhere else. I think it's page 13. Current conditions and environmental objectives, it's page 15. Challenges for the water environment then follows on somewhere, possibly page 20. And then we come to summary programs of measures, and that's subdivided between the summary program of measures and then the mechanisms. And for the life of me, I can't work out where one starts and finishes and the other takes over.
I can understand that, because in particular case of how this plan is put together, they have been worked on together. There's nothing in the directive to say that.
I mean, it's interesting that the schedules you took us through introduced the concept of mechanisms.
Yes.
So, left to my own devices, I hope not to be, that might start at 176, but I mean, the summary programme measures potentially, so far as I could see, ran from about page 23 up to about. Oh, I just found it now, by chance. There's a page with the word mechanisms on at page 79.
That's right.
Good. Is it the snap?
But that's right. So, if I've never placed snap in the Court of Appeal, but yes, that's right.
There used to be an easier way of setting these things up. But in any event, if one glances through that material, it is, as you would say, generic.
Yes.
I think Mr. Wolf, Dr. Wolf, goes a bit further and says this is not peculiar to Humber, this material. This text would be applicable in other regions. So, I mean, it is the same text in all of these, whatever it is, 7 or 8 English plans.
Yes, yes, there's a,
Basically national text, isn't it?
some of that text is national text.
Well, I, at the moment, I can't see anything specific to Humber.
Yeah.
If there is something specific to Humber, it'd be nice to know.
Could I take my lord to the Environment Agency's skeleton arguments in the core bundle at tab 4 and go to page 1771?
Yes, thank you.
That's I appreciate it's perhaps not, it shouldn't be necessary to decode the plan, but that is it decoded.
Yeah, well, I did try working from that. Yes.
The previous cycle
Yes.
produced a plan which for which you could get a PDF and print it and read. But this one you can't.
Well, if you look at page 71, item 3, individual spreadsheets, that takes us to 176. And that effectively is what we've just been looking at in the A3 versions.
Yes.
Summary of measures for Humber River Basin, but in fact that's not quite what it is. It covers the whole country. It's just that if there's anything which has been identified for Humber, you might find it in there.
Yes.
Can we find any Humber material?
Can we find something which is specific for Humber? Bear with me while I. So that.
That might be. Sorry.
So what I will do is have this printed at a still better scale and highlight those which are Humber related, because the particular river basin district is in fact fifth column along, and a number of those are Humber as opposed to all. One of them, for example, relates to 2 river basin districts, the Anglian and the Humber, and that's perhaps not surprising given that they're adjacent. But I'll answer that question by highlighting the still larger copy of the spreadsheets.
The mechanism started at page 79. But is it fair to say that if one reads through to 155, yes, that's the mechanism section.
So if I can perhaps somewhat anticipate the point, that so far as there are national measures national mechanisms, the text is going to be found in each
Yes.
plan.
I'm just trying to identify which part is of that generic nature.
Yes. Without going through it,
To save time, would it perhaps be helpful to have page numbers put against the sections on page 4 of the bundle, so that it reduces the scope for error?
yes, I agree.
And maybe if one tries to read this again alongside the skeleton, it will become clear.
That's not something I will promise, but it's something I'll endeavour.
Any help would be welcome.
It's an objective I will
Thank you.
aim to achieve.
Thank you.
There
Right.
are
Where are we?
4 particular points in respect of the judgment, which I
Right, so we're now on
last,
fourth of your headings.
the last and indeed the shortest lap.
Right, so we're now going to the judgment.
For which we need the judgment, if we may, which I think is at tab 10 in the core bundle. Tab 10 in the core bundle is where we find the judgment. And the 4 points that I want to address are essentially from the judge's conclusions. The judge's conclusions, as the court will know, starts at page 372. Page 372. And I want to start, if I may, by addressing the conclusion at paragraph 134, where the judge says that given that the environmental objectives are water body specific and the programme of measures is created to achieve these objectives, it's counterintuitive to suggest that the measures in the programme of measures could be wholly generic and not focused on whether, when and how the environmental objectives designated for an individual water body would be met. And having regard to, firstly, the material which I've taken the court to in respect of purpose, and the submissions which I have made as to both from the recitals and from the way in which the CIS understands the entire process to work, it is not counterintuitive. And as I've said in answer to my Lord Justice Fraser's questions, if one approaches this from an initial understanding that one is going to find these answers in the programme of measures, then you're going to be disappointed. But that is, for the submissions that I have made, that is not the purpose of either the programme of measures or indeed the plan. So it's not counterintuitive, but as I've also, I hope, made clear, that does not, to use a word, derogate from the ambition of the framework to achieve the environmental objectives for the water bodies. That remains a fundamental and important feature of the directive. But one gets too good for surface waters by implementing the measures. And of course, it is a substantial task of analysis and judgment, along with understanding the particular deployment of the national measures, to answer the question whether or not those measures can achieve those objectives.
But you're quite frankly accepting that if you're looking for that level of detail in all this material, you're going to be disappointed.
Yes, absolutely.
How then, if I could just, I'm going to restrict myself to this one question. How then, under the regulations, Regulation 12, could you properly consult on them?
But very straightforwardly, because you're consulting on whether or not there is a measure that's in place which will address what somebody says is the pressure. And the Fishery Association's case really focuses on the point source discharges. So sewage treatment works, and there are a couple of private discharges.
Yes, but unless someone is going to say that the permitting regulations of 2016 are legally incapable of delivering a solution to a problem in a particular case, there's no point in consulting. The answer to that question is obvious. In fact, the consultation would be, if that is the problem, change the law, the 2016 regulations. But I mean, that would be consultation of a very limited ambit.
The consultation, of course, is on the programme of measures for the district. The question is about the Fishery Association and the BEC. And again, we come back to this fundamental question of approach, that if I am correct in submitting that it is a strategic plan and you're consulting on the strategic plan, it may be that the Fisheries Association does have little to say about the programme of measures and the plan. Their complaint is different, and we're here for the wrong reason. Their complaint is about the way in which the Environment Agency has varied or not varied any particular discharge consent, or the debate may be, has the Fisheries Association got it right? Is it in fact diffuse pollution that causes the problem that they identify? And that is a different question in respect of other people who have an impact upon that particular watercourse. And so the question which my Lord Justice Holgate asks is really, again, central to what the case is about. Is this a consultation on individual water bodies? It comes back to the same point. And my submission, as I hope I've been frank about, is that that's not what the programme of measures is for. And indeed, I go further than that. Both the directive and the Secretary of State are very clear that that is the correct way to deal with this part of the framework. And so this case is not about, in my submission, solving each and every difficulty which there is in respect of water quality and indeed quantity in England. It's about whether or not the strategic planning which the plan and the programme put together here in the UK, do they make the contribution towards the framework's objectives which they're meant to? That's what it's for. And the judge's judgment turns it into something else, and something which is not the function.
Can I ask how the answer you've just given squares then with the directive? I'm just looking at recital 46 on public participation. It's on page 10 of volume 1 of the authority. It's not the only place where public participation is referred to. On the face of it, it seems to be rather specific.
My Lord, could my Lord give me
I beg your pardon, I'm so sorry. Page 10.
Page 10.
Of the authorities bundle, recital 46.
Yes,
That sort of description doesn't seem to be just talking about consultation on one view of the kind of document which we see in the supplemental bundle, which describes basically the legal mechanisms which are available nationally.
taking recital 46 line by line, it's concerned with the participation of the general public, and then it goes to a little bit more particularity, including users of water. And so far, so general. And it's, in my submission, entirely supportive of the submissions which I have made, because it is concerned not with individual specific water bodies, which it could be. It's concerned with river basin management plans. And it's concerned with information about the planned measures. Now, of course, I've already made very clear that it's not an error of law to include a measure which is highly specific. The public may say, do this, it will have this effect on this pressure. And that is, on my reading, what recital 46 is for. It being undertaken at a point in time at which there's a genuine opportunity to participate and be fully informed before doing so. But of course, all of that is predicated upon the analysis and characterization which has already been undertaken.
Is the term measures anywhere defined?
I think that it is. You think the answer is no? I think the answer to that is, unless somebody prompts me otherwise, and nobody is, I think the answer is no. So far as the judgment is concerned, I want to deal with these points as efficiently as I can, and I may cut back the number of points I'm going to make in this regard. I do want to make some submissions in respect of the conclusion which the judge makes at paragraph 142 at page 376. This is having set out her conclusions in respect of the directive and the regulations, then turns at 142 to the statutory guidance, and deliberately that's a document which I haven't yet turned. At 142, she relies in particular on paragraphs 9.1 and 9.2 of the statutory guidance, and I gave some hint of what the submission is in that regard earlier on. If we could go please to tab 17 of the authorities bundle. Tab 17 of the authorities bundle is at 491 onwards. The judge, earlier in her judgment, sets out extensively some of the other parts of this guidance, but I'm going to just focus on pages 520 and 521, because that is where we find 9.1 and 9.2, which the judge relies upon in support of her conclusion. And the submission is firstly that the relevant section for the purposes of the issue in this case is really section 10, environmental objectives. And that is why earlier in the course of my submissions I've drawn attention to those instruments which give rise to environmental standards specifying emission limits and environmental quality standards. But 9.1 is particularly relied upon by the judge. Regulations require the Environment Agency to set environmental objectives and establish programmes of measures for each body of water in England.
And there's the third sentence of 9.2 as well.
Yes, that's right. Now, my submission about that is yes, the agency is to set environmental objectives for each water body, but it is not correct to say that to establish programmes of measures in respect of each water body, for the reasons which I've submitted.
Sorry, how's that different from the language that's on the page?
So the clause and establish programmes of measures for each body of water in England, that's not correct to say.
So it's, sorry, you are saying this is an incorrect statement?
Yes.
Yeah.
I don't really, if I can put it this way, I don't really understand why it's under the heading environmental standards.
So, right.
It ought really, if you were going to say that, you would want to say it in respect of environmental objectives, which is what the case is about.
So you're not submitting that read in context, and bearing in mind this is government guidance,
Yes.
not legislation. When it says to set programmes, I'm leaving out unnecessary words, to set or to establish programmes of measures for each body of water in England, you're not saying that that means that the coverage must be national and that will necessarily subsume every and each and every body of water in England. You're not saying that that's what it could mean in context. You're saying it's just wrong.
Yes, it is.
And so, when one's tempted to ask, when did the department come to that view? Actually,
As a result of the argument in this case,
or December 2023.
yes, it's evidently not consistent with.
So why has it allowed that guidance to remain in place for a year?
That's a question to which I'll seek the answer.
But I mean, it isn't fairly, well, it's a question that perhaps one might naturally ask.
And perhaps it's one I ought naturally to have.
And I'm not saying that.
But
I think an answer, given if it's right to call it a concession, given what you've acknowledged just now, the question does arise, I think.
Yeah. And
this is statutory guidance.
It's statutory guidance.
Under Regulation 36(5).
It is.
Statutory guidance by the Secretary of State to the EA. It's all described as status on page 501 of the bundle.
It is.
So then,
But it's guidance.
perhaps the question I've asked is on a still more secure foundation.
Certainly the judge was entitled to take it into account, wasn't she?
Exactly.
As a sense check for how she was approaching it.
Absolutely. I completely agree.
I'm sorry if I've simply missed something that I ought to have picked up. Was this point made to the judge?
No.
I mean, when I say this point made, was this acknowledgement given to the judge?
No. It's just when one reads the generality, when one reads the generality of 9 and 10, it's clear what's required. But those particular words.
Well, those words perhaps are amplified, aren't they, by what follows in 9.2? And in particular, the passage that my lord referred to, different objectives and standards will apply to different water bodies.
Yeah.
I mean, that's by way of amplification or explanation of the very clear statement in 9.1, isn't it?
Of course, the 9.1 needs to be read consistently with the directive and the regulations. None of which,
Well, you're saying that it can't be.
yeah, exactly.
So that
So
point,
it
I'm not
can't.
sure where that point takes us. If you can't read paragraph 9.1 consistently with what you say the regulations and the directive mean, then reading them in that context is a meaningless exercise.
Exactly. But what I want to,
So that drives you to the concession that 9.1 is plain wrong.
yes, and
Is that right?
it's yes, and it's also in the place that you just wouldn't expect it. You'd expect it in 10.
But you wouldn't expect it in those terms in 10.
Correct. So
You wouldn't expect it at all as it's expressed.
Exactly.
Because obviously you're saying.
Exactly. Yeah.
I understand.
So those are a limited number of points about the judgment.
Well, if we come back to paragraph 142 of the judgment,
Yes.
which says, this analysis is entirely supported by the statutory guidance document produced by the Secretary of State in September 2021. This states in terms, and then she recites what's in 9.1 and then 9.2, which she can be forgiven, can't she, for saying this analysis is entirely supported by that guidance.
Oh, I completely agree. Yes.
Right. So you're conceding that she's right at paragraph 142.
So far,
She's right to say what she does. This analysis is entirely supported by that statutory guidance.
yes, she is.
Right.
But what, of course, the court will note is that what I say about 9.1 and 9.2 is no surprise in the context of what I've submitted in respect of a variety of sources, 4 in fact,
So, I mean,
as far as the purpose is
I mean,
concerned.
without being, I really do hope, without being unkind, it follows from your submissions that the Secretary of State's case to this court is inconsistent with the statutory guidance that is published in his or her name.
Yes, and that's not unkind. It's my case.
It's your case. The Secretary of State for whom you appear has statutory guidance inconsistent with his or her own case.
Yes, that's right.
Right,
And-
understood.
And that's immediately clear from the skeleton argument and from the way in which the response to the OEP is drafted.
Is it acknowledged in the skeleton argument?
I don't think it is.
Right.
So, given the time, I don't think that this is the sort of appeal where the interpretive exercise is to be repeated to a large extent. And so passing the judgment in detail isn't going to assist any more than I've been able to assist already.
Well,
To do so,
The appeal turns on this question: was the judge right in her interpretation of the directive?
that is the issue. And I don't want to further constrain the Environment Agency's opportunity. They need to finish today,
Yeah.
so that Mr. Wolf can have his opportunity.
Thank you very much.
Thank you.
Thank you very much, Mr. Kimball. And Ms. Pindon. Yes, Mr. Fraser.
My Lords, can I start by gratefully adopting these submissions of my learned friend for the Secretary of State, save specifically in relation to the final point concerning paragraph 9.1 of the statutory guidance. I respectfully disagree with my learned friend's submission on that front. I will cover that at the appropriate time in my submissions. But in terms of a structure, I'm conscious that I have half an hour. I want to make some very brief references to the legislation for your Lordship's assistance. Secondly, then to specifically deal with the statutory guidance point. Thirdly, some additional references to the River Basin Management Plan for the Humber. And then finally, some short submissions on the key issue in the appeal.
Thank you.
Taking the first issue, the legislation, this has already been almost entirely comprehensively covered by my learned friend, for which I'm very grateful. I would just like to draw your Lordship's attention to one or two other additional references for information purposes primarily. In the directive, tab 1 of the authorities bundle, Article 4, which is on page 16. This is the key duty concerning environmental objectives. I endorse specifically and emphasise the submission of my learned friend, Mr. Kimblin, in respect of emphasising the opening words of paragraph 1 of Article 4 in making operational the programmes of measures. My submission, this is an operational duty which applies in order to achieve the objectives that are set out in Article 4.1. It is a duty which applies in making operational the programmes of measures, not in establishing or preparing the programmes of measures. The next reference, my Lords, is in respect of Article 11, which again, there has been considerable discussion already, page 25, Article 11, Programme of Measures. I would like to draw your Lordship's attention to the final two sentences of paragraph 1 of Article 11. Maybe that your Lordships have already seen these two particular sentences, but in my submission they are germane to the question of understanding what the programme of measures can be. And then if I could make a brief submission about Article 11, 3G, just as an example. This is an example of a basic measure which must be specified in the programme of measures. And 11.3G specifies that the measure that has to be in the plan, in the programme, forgive me, is a measure for point source discharges liable to cause pollution, a requirement for prior regulation, such as a prohibition on the entry of pollutants into water, or for prior authorization, and so on. In my submission, this is asking for a measure that is for a regime, in general terms, a regime which will achieve what is asked for in 11.3G. It's not asking for specific individual permitting measures or measures within a program of measures which pertain to a particular environmental permit. In other words, the duty that is in 11.3G is discharged by the agency, including within the program of measures, reference to a measure that is about controlling and regulating point source discharges. When it comes to the individual environmental permit context, conscious of the fact that there are several thousand environmental permits operating and managed by the Environment Agency, individual actions that are taken in respect of those permits are at the implementation stage as opposed to establishing them in the program of measures. Finally, on the directives, page 29 of the authorities bundle contains Article 13.5, and my Lord Justice Holgate already referred to this particular provision. 13.5 is the discretionary power given to supplement a river basin management plan by the production of more detailed programs and management plans for sub-basin, sector, issue or water type to deal with particular aspects of water management. This is then given effect in Regulation 32 of the regulations. The short submission I make about this is that it casts some light as to the key question of construction interpretation for this court in respect of what is required to be in a program of measures and a river basin management plan. Because if it was necessary for a program of measures to descend to the individual water body level, then in my respectful submission, it would render Article 13.5 unnecessary. Because the provision for descending to a more detailed level in terms of defining measures in a plan is a discretionary one pursuant to 13.5, as opposed to being a requirement of the primary river basin management plan and program of measures. My Lords, I do use these two terms, and I should confirm what was discussed earlier, which is that although the legislation provides for there to be two distinct documents, one the program of measures, the other the river basin management plan, with the latter only needing to contain a summary of the former.
Just going back to 13.5.
Yes, my Lord.
Taking the first sentence by itself for the moment, you're saying that's consistent with the reading of the directive that says that levels above sub-basin are the object of the program of measures requirement.
Yes, that's correct, my Lord.
But then why put in the second sentence, implementation of these measures will not exempt member states from any of their obligations under the rest of this directive?
Well, my Lord, what I think it...
If they otherwise only need to cover basin and above, why do you need to put that in?
Well, my Lord, I think my understanding of that second sentence of 13.5 is that it's saying that if the agency does go down the discretionary route of preparing a more granular plan, shall I say, a supplementary plan, that doesn't obviate the obligations on it to comply with the other parts of the directive.
But you don't need that if the obligations are only concerned with a higher level. You might need that if the obligations elsewhere are concerned with a lower level, and this is just an overlapping function.
Yes, I understand the point that my Lord is making. In my respectful submission, again, touching on a point that was discussed earlier, I think by reference to paragraph 6 of my skeleton argument about what was meant by the agency's submission, if that paragraph had given the impression that it's unlawful for a river basin management plan and a program of measures to contain a water body specific measure, that is certainly not the intention. indeed, the summary programme of measures that we will look at briefly in the Humber context, at page 176, does contain 2 or 3 water body specific measures. So it's not the case that they can't contain them, but in my respectful submission, Lord Justice Fraser drew attention to the wording of the declaration of my lady, Mrs Justice Lieven, in the court below. In my submission, the issue for the court is whether the terms of that declaration are correct. And I think that's the correct way for the court to proceed in terms of deciding whether the specific formulation, I believe it's page 330 of the court bundle, which is where that order is set out, whether it's correct. And in my respectful submission, it's not a correct analysis or interpretation of the directive. My Lord, if we could just take that up briefly. 330 of the core bundle. There are 2 aspects to the declaration that is on appeal, but they turn on the same issue. The first is under paragraph 2 of the order, whether the directive and the regulations require A, that a periodic review of programmes of measures established under Article 11 WFD and so on must be undertaken at the individual water body level, as opposed to merely at the river basin district level, or even the national level. And then B, the second part of the declaration, is that the programme of measures must set out the water body specific measures to be taken to achieve the environmental objectives for each water body. And in a very short submission, my lords, the agency's case is that the programme of measures is a toolkit. It's a toolkit which needs to equip relevant bodies, including but not limited to the agency, with the measures they need to comply with the operational duty at Article 4.
Sorry, just say that again, which needs to equip
The relevant bodies, including but not limited to the agency, with the measures that they need to comply with the operational duty in Article 4. Specifically Article 4.1. My lords, that's all I wanted to say about the directive. In terms of the regulations, in my submission, there is no material difference between the wording of the directive and the wording of the regulations in terms of disposing this appeal.
Well, I think Part A of Annex 6
Yes,
is completely disapplied, isn't it?
well, my lord,
Regulations. I might be wrong.
I did hear
It's
my
Schedule
lord,
5, it's in Schedule 2, it's Schedule 5.
Schedule 5. If it's okay, I will check that overnight.
Well,
because
I
I'm not
don't-
100% sure I can confirm that.
Well, I have
to
got
you
a,
now.
I have got a reference for you. It's
I'm grateful.
It's at page 216.
I'm very grateful.
Under tab 2 of the authorities bundle. And it's Schedule 5, modification of directives, and this is paragraph 15, and it says Annex 6 is to be read as if Part A were omitted.
I'm very grateful. Well, my lords,
So that is a fairly reasonable difference, isn't it?
it is a reasonable difference, my lord, but I would submit that it's not a difference which changes the outcome of the appeal, depending on whether one is interpreting the directives, the directive or the regulations. Because if we go back to Article 11 of the directive, which is on page 25 of the authorities bundle,
Yeah.
we see Part A of Annex 6 is referenced in Article 11.3a.
Yeah.
But even if one reads that without Part A, one still needs to go on to look at all the necessary basic measures that have to be introduced into the programme of measures under 3B onwards. So all of those still apply. And indeed, there will be a degree of overlap, of course, because some of those directives in Part A of Annex 6 are covering matters which are also covered in Parts B and onwards.
But in a way, I suppose it could be said to make it easier, because when you look at 3A, you only need to go so far as Article 10, and you don't have to trawl through all the different provisions in Part A of Annex 6, because it doesn't exist so far as the regulations are concerned.
I endorse that. I'm grateful for that. So that's the legislation. In my respectful submission, it's not going to hugely assist the court for me to go through all the parallel provisions of the regulations. What I can offer is a one-page note overnight where I just identify where the corresponding regulations fit in a single table that may be of assistance to my lords.
Well, yes, so preferably on an agreed basis.
Yes, I'm sure that can be agreed. It's unlikely to be controversial.
And even if it's not overnight, to have it agreed would be most helpful for us.
I'll certainly endeavour to lead on that, my lord. Thank you.
Don't want to put pressure, undue pressure anywhere.
No. It's no trouble at all. The brief point I wanted to make about the statutory guidance was in relation to 9.1. My lords, I want to do this by reference to my skeleton argument, which is that core bundle page 82.
You want us to look at the skeleton?
Yes, it's the Environment Agency's skeleton, core bundle 82, and it's paragraph 86 of my skeleton, which begins at the bottom of page 81. And it's subparagraph 4. And it's the final two sentences of subparagraph 4, which I would just ask your lordship to read briefly.
Sorry, the paragraph number was?
It's paragraph number 86. 4,
86, sorry.
final two sentences.
Yeah, got that.
Really, that I think was the point my lord putting to Mr. Kingdom.
Yes, and my lords, I accept that I'm not acting for the Secretary of State. I also accept that this isn't my client's guidance. But what I would respectfully submit is a slightly more benevolent interpretation of this than my learned friend Mr. Kinburn has given, because I do consider that, albeit it could have been worded more clearly, I do respectfully submit that paragraph 9.1 can be read in such a way as is consistent with the submissions and interpretation.
But as my lord points out, I specifically ventured that construction with leading counsel for the Secretary of State in the course of argument, and it was.
I appreciate the difficulty
disavowed.
I'm in, my lords. It's simply my own interpretation of the words.
All right, no, I understand.
Forgive me if on the alternative interpretation you put forward, why bother to say it in the guidance?
My lord, I think that could
Not
apply.
really adding anything. Particularly, it's even more confusing if in a sentence which applies to objectives as well as measures. Because there's no dispute that the objectives do have to be water body specific. That could be said to be an indication that Mr. Kimlin is right.
Well, my lords, it's no part of my case to say anything other than this is a poorly worded sentence and it's ambiguous, I'm afraid. But I do say that it can be benevolently or charitably interpreted in a way which is consistent with my submissions on behalf of the agency. That's as far as I'll take the point. I would just briefly like to highlight for your lordship's information again a couple of other relevant parts of the statutory guidance, which in my submission are, again, may have some bearing on the question of interpretation. The first is paragraph 14.17 to 18, which is on page 540. again, in view of time, I'm afraid I'm not going to be able to spend any time on this, but I would just invite your lordships to consider 14.17, 14.18.
So page 540.
Page
which one?
540.
Which one?
This is in the authorities bundle. Yes. And then the final reference, again, I won't have time to make any submissions on the point, but just to draw attention to paragraph 14.24 of the statutory guidance on page 542. My lords, again, conscious that I have 10 minutes, I just want to very briefly, subject to the call. I'm being asked by.
I think Mr. Wolf is generously saying that
Yes.
you haven't got just 10 minutes.
But
Since he said that, I would say that we will rise at 4:15 and you can have until 4:15.
I mean,
I think that's what I
enormously
meant,
grateful.
I'm sure it is what you meant.
I didn't want to assume that Dr. Wolf is speaking on behalf
That's
of
fine.
lordships.
I don't want you to rush, actually. We
I'm
don't
grateful,
want you
my
to
lord.
rush. But 4:15, I think, is a reasonable.
That's an absolute
Cut
long
off,
stop, yes. Thank you. So, in relation to the plan, we have already touched upon this, but just to start in the supplementary bundle, please, on page 4, and my Lord Justice Holgate noted that there is a list of documents on page 4 of the supplementary bundle which comprise collectively the Humber River Basin Management Plan. And I had sought in paragraph 39 of my skeleton, recognising the difficulty of looking at the bundle and trying to understand where all these bits actually are, I had sought to provide bundle references for each of them. But certainly, my lord, we can go away and make sure that those bundle references are fully correct.
Right.
But essentially, paragraph 39 of my skeleton, which is on page 70 of the core bundle, that is the list of the 9 documents that make up the River Basin Management Plan. And then at paragraph 40 of my skeleton are the 6 documents which make up the so-called summary programs of measures. And I say so-called because in actual fact, they are the programs of measures. There is no distinct document. My lord, what I propose to do is just very briefly introduce your lordships to how the plan is set out and structured. And again, I'm going to largely do this by reference to pages which can then be subsequently read, I'm afraid, just again in view of time. But at page 13 of the supplementary bundle, we see...
I'm sorry to interrupt, but can I just mention very briefly,
Yes.
so when you look at this overnight,
Yes,
we don't have any more difficulties tomorrow.
yes,
What I'm finding, if you look at your skeleton 39 and 40,
yes,
I follow how in 40 you're setting out the pages of which the different bits of the programme,
Yes.
programme, start. So item 2 starts at page 79,
yes,
mechanisms, and an individual spreadsheet starts at 176.
Yes.
If you go back to 39,
yes,
in between those 2 reference points, we have at item 6 and 7, the RBD data explorer
Yes.
and the map explorer.
Yes.
I can't see what they've got to do with measures.
They have nothing to do with measures.
Yeah, but they appear in the middle of it. You can see why it's confusing.
Well, my lord,
So I won't say any more. If you can just help out there, so that
yes, no, understood. I think that's a consequence of the bundling as opposed to the way in which it's set out.
French would say n'importe.
My lord, I can certainly take that away, and but certainly that's not the way in which it might appear to someone browsing
I
it.
don't want
But
to go away and then find I'm still struggling.
yes, and it is difficult to navigate.
Take up your time. I apologise.
No, my lord, it's a perfectly fair comment. So, my lords, at page 13 of the bundle, we see a brief introduction to the summary programme of measures in the heading. And then in more detail, that is then elaborated on page 27 of the bundle, the supplementary bundle. This is in section 1, with the headings. The heading of this document is the summary programs of measures, and then section 1, introduction. This then introduces what the programs of measures are. And we see the third main paragraph starting programs of measures. Programs of measures include on-the-ground actions, for example, improving a sewage treatment works and the mechanisms, tools and approaches to ensure the actions are delivered. They include exercising statutory powers set out in legislation to deliver actions on the ground. We then get at page 28 different ways in which the summary programs and measures were developed. This is halfway down page 28. There are 4 bullet points. The summary programs and measures firstly come from collating measures that are developed during water planning processes, for example, WINEP, that my learned friend Mr. Kimblin was discussing. Secondly, by collating measures developed primarily to achieve different outcomes, for example, increased flood resilience, but which also deliver benefits that relate to achieving environmental objectives. Thirdly, and importantly for the question of public participation, by people's involvement and input to river basin planning, in particular views expressed on key challenges and measures through the challenges and choices in the draft public consultation. So it's envisaged that members of the public will participate and put forward suggestions for measures that can be included in the programme of measures. And then finally, collating initiatives developed, for instance, by government to deliver multiple outcomes, including those with measures to help achieve the environmental objectives. My lords, if I could just turn the page back to page 27. In 1.1, very last part of page 27, we see the words, the measures to achieve the environmental objectives for water bodies and protected areas in the river basin management plans are summarised in several ways, reflecting their relevance to specific objectives, sectors or river basin districts as described below. This will allow the reader to access the summary programs and measures for their river basin district from different perspectives. So it then explains the different ways in which the document is presenting the various measures. One of them looks at them in terms of the different environmental objectives, so deterioration, achieving good, and so on. Secondly, a summary of the measures for each sector, that's section 4. So you might have different sectors, for example, water industry. Thirdly, in section 5, over the page, top of page 28, summary of the main measures to deliver expectations for river basin management planning as set out in ministerial guidance. Section 6, the main mechanisms. That's the mechanism section that starts at page 79 of the supplementary bundle. And then when one goes through the document, one sees, for example, again, I'm just going to be very broad brush and just identify an example on page 31. This is in the section beginning. This is at the beginning of section 4, near the top of the page, page 31. Programs of measures for each sector. Then you have at 4.1 water industry. It identifies the investment that is being made by water companies through WINEP and the period from 2020 to 2025. As my lords may know, a few weeks ago we had the final determination by Ofwat for the period 2025 to 2030. And then we have the measures, the third paragraph down from the beginning of 4.1, measures for the water industry are broadly divided into those related to the collection and treatment of sewage and those related to the supply of drinking water, and then a list of what the measures include. And we see over the page, top of page 32, the second paragraph, environmental improvements for the period 2025 to 2030 are now being planned. Water companies must improve their performance, which has stagnated in recent years, and so on. So what I'm seeking to do by drawing reference to these, just as an example, is that if one reads the programme of measures as a whole, one sees, in my respectful submission, quite a detailed suite of measures which form what I say is the toolkit that is then taken away by the agency and other bodies to comply with their operational duty. This is the suite of measures which, taken together and collectively, equip the public bodies that are involved with what they need to achieve the environmental objectives at the water body level.
And the summary of the programme of measures is the same as the programme of measures.
Exactly, my lord.
Right. So if you look on page 28, there's a few bullet points, paragraph that starts, please note, and then it says, it should also be noted that this is a summary of the programme of measures.
Yes.
Not every individual may be included. Is there anything in this document that says the summary programme of measures is the same as the programme of measures? No, that's something which I can confirm because there is no previous separate document called the programme of measures. This is it. So that in my submission, that is an error to say that, because this is the programme of measures. What it may be indicating is that there could conceivably be measures which will be taken, could be taken, which aren't included in here. But that's not the same as saying that there's a separate freestanding document called the programme of measures.
Are you saying that the programme of measures is always the summary programme of measures?
Certainly that's the way the agency's always done things, ever since the directive was introduced in the 3 rounds that there have been river basin management plans.
But does that stand with the way in which the directive is expressed?
In my submission, it does, my lord. If we go back to Article 13.
Yeah. This is the river basin management plans.
Yes. This is the requirement to prepare the river basin management plan.
Yes, but shouldn't we be looking at Article 11?
Yes, so Article 11 is the programme of measures. You're correct, my lord. That's the requirement to prepare the programme of measures.
And where is the provision for summary?
The provision for a summary, the starting point is to look at Article 13(4) on page 29, which says the river basin management plan shall include the information detailed in Annex 7. And then in Annex 7, among the things which need to be included,
That's right.
I can give my lords the reference.
Page 87.
Page 87, yes.
Is it item 7?
Page 87, item 7, yes.
That rather suggests it ought not to be the same.
Yeah. The way I would submit this is the legislation clearly envisages them being separate, but there's nothing in law to preclude them from being the same thing.
Well, is it even clearer though in the domestic legislation?
Yes.
I mean, because if you turn to tab 3, page 111,
Yes.
you get 2 for the price of 1.
Yes.
Regulation 12. There, the agency has got to prepare and submit to the Secretary of State the environmental objectives in accordance with Reg 13 and a programme of
Exactly.
measures
And it's every 6 years.
in accordance with Regulation 20. But our friend, the River Basin Management Plan, is dealt with entirely separately in Part 6,
Yes,
which you don't get to until Regulation 26.
correct.
So it couldn't be any clearer, could it? They're separate documents.
Well, again, my lord, my submission would be that they are envisaged to be separate documents, but there's nothing to preclude them from being the same. One could have the same document which is prepared and updated and submitted for
Put it this
approval.
way, the only way in which the Environment Agency and the Secretary of State can discharge their responsibilities to produce a programme of measures is by treating what is described as a summary as not a summary, but a programme of measures.
Exactly, my lord. Yes. So
It does follow there isn't a summary of it.
there isn't a summary. So, my lord, the way I would, again, if one looks at Reg 12 on page 111, we see 12.6 is the relevant duty in terms of reviewing and updating. And that says the appropriate authority must ensure that for each river basin district, the environmental objectives and the programme of measures are periodically reviewed and where appropriate updated. And then they have by the 22nd of December 2021, and then subsequently 6 years after that. So what the agency has done, which is consistent with what it's
3 years under subparagraph 7 to put it into
to
operation.
make it operational, yes. So effectively, the preparation, the submission and the approval of the river basin management plans is the agency's compliance with Regulation 12.6, as well as complying with the actual river basin management plan regulations within the 2017 regs, if that makes sense. There are no, it's the same 6-year cycle the agency has decided, and again, I don't understand this to be challenged as unlawful, to align the two processes together. So that when the agency reviews and updates the programme of measures, they also review and update the river basin management plan. And then similarly, when the Secretary of State reviews and decides whether to approve the river basin management plan, they are also deciding whether to approve the updated programme of measures and environmental objectives under Reg 12. Turning back to the supplementary bundle and back into the river basin management plan and part of the summary programmes and measures, if we go next to page 76, right at the bottom of page 76 is the new section heading, River Basin District Summaries. This section describes and links to the summary of measures for each river basin district. And then we see at the top of 77, the summary of measures for each river basin district spreadsheet presents the measures currently planned for each river basin district. Now, before I look at the next bit of text, just confirm for your lordships that there are a number of different river basin management plans, one of which is the Humber. I think there are 9 in total. For each river basin management plan, everything that one sees here, so all of these parts of the summary programmes and measures are the same. Indeed, the whole river basin
Can you
management
say that
plan.
again, sorry, for each?
For each, so for everything in this bundle, so every part of the river basin management plan is the same for each plan, save for the spreadsheet. So the spreadsheet is the Humber specific part of the summary programme of measures and the Humber specific part of the river basin management plan.
Spreadsheet starting at page 176.
176, exactly. And that's not to say that the spreadsheet only contains measures which relate to the Humber. They contain measures which are national, which will be in all the spreadsheets, and then measures which are Humber specific. And indeed, more granular than that, there are some measures which are water body specific.
In the schedule?
In the spreadsheet.
I thought we were told that there weren't.
That's correct. And it's possible to miss them because again, it's quite difficult.
Is this
to
another
see.
difference between your case and Mr. Kimlin's?
I think it's a difference, but it's not a material one in the sense that I think the point that Mr. Kimblin was saying, as I understood him, was that it's not a requirement for the spreadsheet to
Right.
descend to the water body level for every water body. So in the context of the Humber, there are, I think, just over 1,000 water bodies.
Yes, I mean, this is not in any way to drive wedges or anything
No.
like that, but just to get a clear understanding of your
That is
respective
correct.
arguments.
That is my position.
So
Yes,
Again-
but the question that I was raising was whether, as a matter of fact, there were or weren't river basin, water body specific, water body specific measures in the schedule that we were looking at, and I thought we were told that there weren't.
If that was so, that was an error. That's not correct.
Maybe I misunderstood.
Certainly we'll highlight those that.
Yes.
Yeah, no, that's fine. If we've
When we
clarified
produce-
it, then well and good.
when we
I
produce
thought-
the larger format,
I was asking about Yorkshire and then specific bodies that were, or organisations that were the lead bodies.
yes.
And
My
I
lord-
thought,
yes.
well, if I misunderstood the answer that was given, then well and good. And
This exercise may be easier
Okay.
once we have an A2 version of this document.
yes, fine, all
But
right.
effectively, what we have is a series of columns along the top.
But anyway, you're both saying that the schedule contains water body specific measures.
Yes. I think it's three.
Identifying the water body by name.
Yes.
Thank you.
And the reference number. We'll highlight which ones there are. There are three. But save for those, there are some which are then catchment specific, which is the next level up from water body level. But then a large number of the measures, it's fair to say, are national measures. And the idea then is that these are national measures which form part of the toolkit. I am going to keep using that word because I think it is a helpful way of describing the agency's case on what the programme of measures actually has to be. Is that there are national measures which are then made operational at a water body level. For example, again, just to take an example, WINEP 2019, huge programme of Ofwat approved investments that have been costed and approved. All of those will involve water body specific improvements being made. They are identified in the River Basin Management Plan Programme of Measures spreadsheet as a single line saying WINEP 2019 Water Industry National Environment Programme Schemes, sewage.
But where are you looking?
So this is on page 176.
Yeah.
The top row.
6, 7. It's the seventh row down.
Yeah.
My lords, if I could just
Sorry, the point in a nutshell is that the WINEP process, the output is approved individual schemes.
absolutely.
It's just that the individual schemes are not being mentioned separately by name.
Correct. And part of the reason for that, my lord, as you may well know, given other cases, is that the WINEP timeframe is out of sync with the River Basin Management Plan 6-yearly cycle. So there isn't an alignment. So when one is updating a plan, coming up with a programme of measures, that doesn't align with the dates, with the 2015 to 2020, 2020 to 2025 WINEP process.
So what the document is doing is noting schemes which have been
Yes, exactly. It's a
possibly in the past.
it's a catch-all provision there for all the schemes across the Humber, which will be applied at a water body level and are known at the time.
Well, exactly, they've been identified already, so
Yes.
you might as well mention them.
Yes. Well, that's the case against us. Whether it's unlawful not to have done so, I would respectfully disagree. But my Lord Justice Holgate asked a question about the blue and whether the blue is significant, and then followed by the green. The blue, the wording is linked to 2027 outcomes. The green says not linked to 2027 outcomes. Now, before I explain what those two differences are, if I could just go back to page 77 of the supplementary bundle. This is where the summary of measures is and the spreadsheets are introduced. And here it says that this is the first larger paragraph at the top of page 77. The measures include planned measures where funding has been committed or there is an established funding mechanism. So that would be the WINEP price review 2019 approved schemes, for example, the ones we were just discussing. For some of these measures, there's confidence about where and when the outcomes will be achieved, whilst for others there is currently uncertainty about the specific locations that will benefit from the measures. Where there is confidence about the specific locations that will benefit from the measures, this confidence is reflected in some of the water body objectives proposed in the plans. These measures are a small subset of the programmes of measures, and the outcomes they deliver represent a conservative view of what will be achieved by 2027. We then get where there is currently uncertainty about the specific locations that will benefit from the measures. This uncertainty is reflected in some of the water body objectives. These measures include the new government initiatives described in section 4.3, the WINEP Price Review 2024, which of course was only concluded in December 2024, and then a number of agency-funded projects taking place between 2022 and 2027. So going back to the blue and the green on 176, and again, I'm taking this all very quickly and it may be coming across quite bewildering, but the blue is intended to reflect those ones where there is confidence about these are funded schemes with certainty and they will be coming forward in specific locations.
By 2027.
By 2027. Whereas the green refers to not linked to 2027 outcomes. And again, it's difficult in the small format, but in the middle of page 178, over the page, page 178, there one sees towards the middle, just below the middle, that one of the provisions is Water Industry Asset Management Plan Price Review 2024 sewage. So again, that's saying that at some point in the life of this plan, there's going to be another massive approval by Ofwat of funding for schemes of improvement, but we don't know whether they are going to exist at the time of making the plan, and that's why they're in the green box as opposed to the blue box. And that's why it's not possible for the agency to say with certainty that they can be linked to 2027 outcomes. As a matter of practice, of course, Ofwat approving a huge investment last month may well result in measures which are made operational by the end of 2027. But this is for a period from 2025 to 2030, so some of them may well not come forward until after 2027. But that's again just an illustration of the point. My Lord Justice Holgate, I think, asked a question in relation to the Catchment Data Explorer on page 159. Just want to make sure I've covered that. And then I think I'm going to be at the end of my submissions. I'll just make a very brief concluding submission after this. 159. My Lord asked a question about the box in the bottom right-hand corner of page 159, where it says disproportionately expensive, disproportionate burdens, good status prevented by a HMWB designated use. What that means is that the Upper Costa Beck is a heavily modified water body, which means that its objective is not good ecological status, but good ecological potential. And the reasons there are the reasons, again, this is not explicit, but I'm saying this on the instructions, that the reasons there are the reasons for the extension of the deadline. So the deadline is supposed to be 2015 under the directive, but then there's again, to use the word discussed earlier, derogation. There's provision within Article 4 for extending deadlines. This is the deadline which has been extended to 2027. The reasons box is seeking to explain, to give reasons for that extension of the deadline.
There's quite a lot of toing and froing on that point in the pre-action protocol.
Yes, my lord. That's not something I'm going to be able to cover.
No, I'm not suggesting.
But
I'm
yes,
not suggesting
there is to and fro in relation to that. Correct. So, my lords, with that, if I could just very briefly wrap up.
So the objective is,
Yes.
is not good status, but good potential
Good ecological potential.
and good chemical.
Good chemical, exactly.
Right.
So final submissions are firstly the issue is whether the declaration of Mrs Justice Lieven on page 330, paragraph 2 of the order is correct. The agency's submission is that it is not. This is fundamentally an exercise of construction of the directive. In my submission, there is no express provision within the directive that programmes of measures are to be water body specific, nor can such a requirement be implied as a matter of construction of the relevant provisions. A programme of measures may contain water body specific measures, but that is not a legal requirement. There's no dispute at all between any of the parties or the judge below that environmental objectives themselves need to be water body specific. But where we respectfully part ways with the High Court on this is whether the programme of measures needs to be water body specific. We submit that the programme of measures may be as it is, as it has been approved, namely largely at a national level or river basin district level, albeit it may include some water body specific measures. The question for the court, or forgive me, the question for the Secretary of State in deciding whether to approve the programme of measures is whether that programme adequately equips the relevant bodies with what they need to comply with the operational duty in Article 4. So the programme of measures will contain national measures, for example, permitting, WINEP, which is then operated or made operational at a water body level.
Can you say that again? The question is whether the...
Yes. The question is whether, the question for the Secretary of State is whether the programme of measures adequately equips the relevant bodies with the measures that they need in order to comply with the operational duty, as I call it, in Article 4(1). In other words, in making operational the programmes of measures to aim to achieve the environmental objectives, can it do that? Can it do that with the measures that it's given in the programme?
England, the it is the Environment Agency.
Largely, my lord, but there are other bodies that have responsibilities
Exactly, that's
for
why I asked
delivering.
the question.
So certainly the Environment Agency, but also other bodies. And there is a requirement in regulation.
So isn't it a bit, I mean, if the programme of measures refers, for example, to the statutory functions which the EA has,
Yes.
or another regulatory body, enabling it to secure an outcome, the test you formulate is, does the programme of measures adequately equip the relevant bodies to comply with the operational duty? Well, for the most part, all it's doing is summarising the legislation and the relevant policies. How can anyone tell whether from that, whether the relevant regulatory bodies are adequately equipped?
Well, it's a question of seeing whether the measures have the mechanisms that enable the bodies, including the agency, to carry out their responsibilities as regulators.
I mean, it comes like almost back to that question I was asking on consultation.
Yes.
What's the purpose of the consultation here? Well, it seems to come down to whether the legal mechanisms are sufficient to enable the regulators to do their jobs, or whether the regulations need to be improved. I mean,
Well,
is that really what the plan is about?
my lord, in my submission, it doesn't rob the consultation of any meaningful purpose to have a consultation on a programme of measures of this kind. It's still the case that members of the public, interested persons, can participate in the consultation, consider the measures that are put forward. They aren't going to have water body specific measures to comment on and critique. They aren't. They just simply aren't going to have that. But they can say, we think, for example, there should be a measure in our water body to do this. They can put forward those examples in the consultation process. As I referred to earlier, the agency in the plan recognises that one of the sources of the programme of measures is measures volunteered by members of the public. And of course, the other critical way in which members of the public are involved in the consultation is by assisting in the production of information about the status of individual water bodies. Because of course, measures are just one part of it. Members of the public also can engage in whether it's accurate or correct to say that one of the reasons for not achieving good is correctly stated. They may say, well, actually, there's another reason why it's not good, which you've missed from your data. So that there is a meaningful role in my submission for members of the public to participate in a public consultation in relation to a plan which is formulated in the way that the agency has formulated it. I appreciate that it's not going to give them a chance to critique, scrutinise individual water body specific measures for all 4,929 water bodies in England. But it's still meaningful. Unless I can assist further, I'm conscious that I've trespassed quite significantly beyond 4:15, my lords. But if there are any further
Those are
questions,
your submissions.
those are my submissions.
Thank you very much, Mr. Fraser. Well, thank you all very much. We'll resume in the morning then at 10:30. Mr. Wolf, you will start your submissions.
I'm grateful. I suspect there may be a bit of domestics around documents that you've asked for, but in principle, yes.
That's not going to take more than a few minutes, is it? No, well, we'll start at 10:30. Thank you. 10:30 then. Thank you.